Welcome to the channel. Let me know if you're a fan of Julio Foolio. Drop down in the comment section, RP Julio Foolio. The head trial.
So we will proceed forward on the motion shortly. I do just want to talk schedule first. We have 100 jurors for Monday morning, and we will be picking the jury in courtroom 1. And for the record, Mr. McClyment, I'm familiar with you. If you can tell me your co-counsel again for the record.
Life Malcolm, Your Honor, for the record.
Mr. Malcolm?
Yes, Your Honor.
Okay, thank you so much.
Okay.
And for the state, we have is it Ismer?
Yes, Your Honor.
Harmon and Miss Doherty. Okay, very good. So Mr. Malcolm and Mr. McClyment, I don't know if you're familiar with courtroom 1. It is over in the civil complex, the George Edgecombe Courthouse on the 6th floor. And when we're done here, if you would like to go over and just take a look at it, I'm sure that would be fine, just so you have an idea. We're gonna pick the jury in that courtroom, but try the case in this courtroom. So we do have a seating chart. Have they been given a copy of the seating chart?
Yes,
Okay. So you can see on the seating chart, it'll be jurors 1 through 100. So you'll be able, when you go into that courtroom, you'll be able to take a look at the seating chart and get a better idea of what it actually looks like. So this is not a death penalty case, but due to the fact that there may be a number of individuals that know something about this case, I may do a similar process that I would do in a death penalty case, but I just wanted to speak with you all about it. So due to the fact that we'll have 100 juror slips or questionnaires for you all to review, Madam Clerk, what's the earliest do you think we'd be able to get those slips?
What time is it?
Well, I'll have the attorneys be there as soon as you tell me the slips would be available to review.
Like 8:45 is the earliest, just because action's not.
Okay.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without having to go.
Okay. So I'm going to ask the attorneys to be at courtroom 1 at 8:30 in the morning. And once the panel of 100 is pulled, the clerk's office does have the ability to send the questionnaires over to the in-court clerk for them to be printed up before we even actually get all 100 people brought over to the courtroom. So what I may do is give you all some initial time to begin reviewing those slips. And then I may do what I would do in a death penalty case, where I do an initial voir dire of the panel with regards to any request for excusal due to scheduling conflicts, and also knowledge of the case. And in a death penalty case, I normally do those on an individual basis. So we can see how many individuals we have that raise their hand as far as to one of those 2 questions. And then I can decide how I'm gonna do it. But definitely any individuals that have knowledge of the case, that will be done on an individual voir dire basis. And then I'll make a decision with regards to individuals that are claiming hardship once they raise their hand, if I'm going to do that individually or just do it as part of the group. So related to that, I'm going to need a stipulated statement of fact from you all that you've worked on that I can read to the jury. And that way they can at least have enough facts, so that way they can hopefully tell us yes or no, I think I know something about this case, or no, I don't. All right. So once I've done the individual voir dire regarding any knowledge of the case, and once I have questioned the jurors about if they've got a hardship request to be excused, then I would begin just my part of the initial voir dire. There's a certain spiel that I do, which takes a little bit of time, not too terribly long. So my point is, I think that will probably take up most of the morning. So whatever juror questionnaires you still need to review, you should be able to have sufficient time over the lunch break to finish your questionnaire review before I turn it over to you all. Just so you know that with regards to the voir dire I will do regarding hardship requests or knowledge of the case, I will do the initial inquiry of the potential juror. And then if you all have follow-up questions, and then I will give each the state and the defense a chance to do follow-up questions of that specific juror, but limited only to that issue, whether it's either knowledge of the case and or a hardship challenge. When we break for lunch, then I will ask you all if you agree to any of those individuals being struck for cause. At that point, if you all agree and I agree, then I will go ahead and dismiss any people that are obviously going to be gone. If either side objects at that point and says, no, I don't agree, it's a cause challenge, I want to try to rehabilitate or I want to question further, then great, they stay on the panel and I don't strike them. I would only strike them if you all agreed and I agreed that it was a cause challenge. Okay?
Judge, I don't want to cut you off. There's a co-counsel in the waiting room.
Oh, that's a good question. Yes, thank you.
Thank you.
All right, welcome. Let's see, Miss White, let me see here. Hello, Ms. White. Good morning. I was just going over kind of the jury selection process, and your co-counsel will be able to relay to you what I said. All right.
No problem.
Okay, thank you. Okay, so any questions just on process for Monday morning?
Nothing for the defense.
Okay, all right, very good. Okay, so I would assume it will take the rest of Monday to pick the jury. Hopefully we can get it done by close of business Monday. And then we would be, assuming that's the case, we would begin with opening statements on Tuesday and then calling of witnesses. Obviously, if we get bogged down in jury selection and we can't wrap up Monday, then whenever we wrap up Tuesday, you all should be
Yungeen,
prepared to do opening
it's
statements
over with
and
for 'em now.
be prepared to call a witness, at least one or
That's
two.
why you got to stay out the way.
Just so defense knows,
You have to stay
we
out the
work
way regardless
9
of
to 5.
what's going on or what your
Okay.
homies did.
and when I tell you it's a 10-minute break, I mean it's a 10-minute break. When I tell you it's a lunch hour recess, it's a lunch hour recess. So if a witness is on the stand and it's 5 o'clock and we can finish that witness, then we'll work past 5 o'clock to get the witness done. But I do try and be honest with the jurors about the time commitment, and so it is.
She
9 to
nervous.
5, but we
Y'all
do
see her. She nervous. She
So,
looking real
I'm not
nervous.
one to
She
waver
know
when it
exactly
comes to
what's
breaks.
finna go down.
Anything
And as y'all can see, she really don't care because she got herself into this. And next thing you know, what did she do? She try to act like it was all type of like stuff going on in her life, and to the point where she had to do this and all. No, you don't have to go out there and commit these crimes with these people, regardless of how cool y'all is. At the end of the day, you should never put yourself in a situation that you can't get yourself up out of. And it all falls back on Yungeen Ace. And it's sad that Yungeen Ace got to even go through this, but this is what we got to go through like every time. Every time. Like real talk. So I want y'all to know this is something that we see happen all the time, man. And I just want justice for Julio Foolio. Whoever don't want justice for him and y'all his ops, you feel me? Then just continue to be his ops. But RP Julio Foolio.
else, just kind of procedure wise, any other questions you guys have about jury selection trial?
Judge, I know that we are scheduled for 2 weeks, and the majority of our witnesses, we have a lot of witnesses that we're making travel arrangements, and most of them are available the first week, but there are, I think 2 or 3 that we're planning for the second week. I don't imagine that we will get done early, but I just want to make the court aware of that. I know that we were dealing with vacations, and there were some other witnesses that are here out of state that are not available until that following week.
That's fine, but following week means Monday,
Yes.
right? Yeah. So they're not available the first week. That means they must be here and available Monday.
Yes.
Okay?
Thank you, Judge.
Okay?
Your Honor,
Yeah.
is there a time limit on opening statements?
Yeah, there is a time limit on opening statements. You guys each have 1 hour. Okay.
Your Honor, I have a question as well about
Yes.
scheduling.
Yes.
Do you handle a morning calendar, or are you expecting to start
No.
with trial at 9 a.m.?
I just try cases. That's what I do. So there is no morning docket. There'll be nothing interfering. So you don't need to worry about that.
Understood. Thank you.
Okay. Okay. Well, if there's no further questions about process, then let's go ahead and turn to the motions.
Why can't you stay organized? I've experienced this myself, and it's called chronic impulse control, where you prioritize.
Judge, we have 2 in limine motions.
And I did review them, and they appear to be kind of fairly standard. So I don't know if there'll be any objection or not, but let's start with the state's motion in limine regarding asking the defendant, counsel for the defendant, to refrain from making any direct or indirect mention whatsoever at trial regarding self-serving hearsay statements of the defendant unless being offered as a confession or admission by a party opponent. Additionally, any self-serving hearsay statements made by the defendant to any other defense witnesses or co-defendants. All right, defendants, any objection to this motion?
No, Judge. Self-serving under the law, we follow the law.
Okay. And with all of these, I'm going to grant the motion with the understanding that if something changes at trial, and if you all think, the defense thinks that we need to readdress that, you just have to bring it to my attention and let me know before you get into this kind of evidence. All right? So if things change, the door's always open to discuss it.
And just for the record, we're looking at the second motion.
This one is titled State's Motion for Order in Limine, so I think this is probably the first one.
It is,
Oh,
yes.
like that was filed back in December.
That was filed on the 31st day of July.
Oh, I just have to
All right.
The groundbreaking of all the first one.
All right, next up is the state's second motion for order in limine. And this is a number of paragraphs. All of this stuff appears to be fairly standard case law. Is there any objection to paragraphs 1 through 5 of the state's second motion for in limine?
No objection to paragraph 1.
Okay, granted.
No objection to paragraph 2.
Granted.
I mean, no objection to paragraph 4.
Okay, granted.
Okay, well. Judge, can I see the motion you have before you?
Yes.
Because I'm looking at a motion that is, and maybe this was a mix-up on our part. You have one titled second motion
Yes.
for order in limine?
I do.
Okay, all right. All right, you probably have the correct one then. I'm looking at something I think was, and I will admit that a lot of this was cutting and pasting from prior motions on other cases.
Sure, here, just take a look at what I'm
Okay,
referring
thank you,
to.
Your Honor, I apologize.
And then make sure defense is looking at the same thing.
Okay, yeah, this is right. Yep, that's it. Thank you, Your Honor.
Okay. All right, so far defense stipulated to paragraphs 1, 2, 4, and then are you objecting to,
And 6 was also stipulated.
okay, that's granted.
This paragraph 5, I completely understand. And 3. And 3, I guess also I would object to that.
Okay, and Mr. Harmon, in paragraph 3, what is it you're getting that here.
Okay, so in paragraph 3, what we're seeking to prohibit is if a witness has a prior felony conviction or a conviction for a crime involving dishonesty or moral turpitude, such as petty theft or worthless check or something like that, that the defense be prohibited from asking or inquiring about underlying facts of the case or the nature of the charge in that case.
Unless the witness testifies incorrectly.
Yes,
Okay.
unless the door's open.
Right.
somewhere.
My understanding is that this one from before. So I'm not sure if 4 and 3 are kind of.
Well, it is basically 4 is just, we're seeking to have an understanding as to the appropriate way to impeach with a prior conviction or crime of dishonesty.
Yeah. So
So if 3 is pretty much the same as 4, we have no objection. We don't intend to ask about to impeach witnesses with underlying facts of the criminal case that they had.
okay. And then the only question I would have on paragraph 3, it does state that concerning the underlying facts and nature of any pending criminal charges.
Right.
So
So
that's a different
it is.
analysis than.
So I think in the second sentence of that paragraph, the factual allegations, nature of the charges pending are irrelevant to alleged bias or motive. The state would have no objection to the defense asking about the offense level and the exposure to the witness, the possible sentencing exposure.
Hey, how do I export this PDF? Show me how to find the new hire
Real
man.
quick, can you show me how to? If your coworkers are asking you.
If it's a first-degree felony, then you're looking at 30 years. Second-degree felony, 15 years. I think the case law that I cited supports the fact they cannot get into the nature of the case and then start trying the case, basically.
And would defense or even state be able to get into the jurisdiction?
I believe so, because it would go to the bias. They would have more possible motive to testify favorably for us if it's here in Hillsborough. So.
Okay. So, Mr. McClimate, so you all are in agreement that when it comes to the underlying facts of any prior conviction, that's not admissible unless somehow the door's open if the witness doesn't testify accurately. When it comes to pending criminal charges, if any witness has a pending criminal charge, you all would be able to discuss offense level, like what degree felony or misdemeanor, what the maximum penalty exposure would be, and the jurisdiction where those pending charges are.
So yeah, the only objection I would have is that it should be limited to just those 3 things. Right? And I'd imagine, now that it's explained a little bit, that one of the witnesses, Robert Howard, because he does have a pending case in state and federal court, I would imagine that maybe this is to limit. Questions as to him, but we did take his deposition, I think 2 days ago. He did testify that he was open for a cooperation agreement, and those questions should be fair game for his credibility.
I agree.
Okay, that's fine. So as to that witness, you can get into the fact that he is specifically stated he's hoping to get some type of cooperation agreement. Okay? And then as a result, I don't know if he's been given one or not, but if he has not been given any type of assurance or agreement, the jury can hear that. Or if he has been given some type of assurance or agreement, the jury can hear that.
Yep.
Okay?
Yes, sir.
All right, so it sounds like after we've discussed it, everyone's in agreement. So that motion, paragraph 3 is granted as we just discussed. Okay, so then 5, is that basically this similar issue?
Well, it's similar in that it would be asking a witness about misconduct or prior bad acts that are not convictions.
Okay. Any objection to that?
Only, obviously the state opens the door because they have asked the court to allow them to get into the history of the violence between different gangs.
Sure.
And neighborhoods. So to the extent that I'm cross-examining a witness about those things, and I think that is all fair game.
She shouldn't have never involved herself in street beef. And street beef went on for a long time, for many, many years. ATK and KTA, like, come on now, it was so many bodies dropped and so much blood shed behind that.
Yeah, I agree.
Yeah.
So
No
it's-
objection to that, Judge.
It's granted with the understanding that if the state has opened the door to a specific.
I want y'all to let me know down in the comment section. Do y'all think that this girl is actually gonna make it at this situation by letting them know the things that she got herself into, that she, like, basically she want the main front guy for all this, but she was with them when they did it. She was in the same car the same night. I want y'all to let me know down in the comment section. Let me know y'all honest opinion about this, because she about to lose her life over a split moment decision. One mistake can mess you up for the rest of your life.